So I have a lot of clients who will ask me, can you get a DUI when you're under the influence of marijuana? The answer is absolutely. However, they're handled a little bit differently. Marijuana stays in the blood for a much longer time, and therefore it's harder to understand or to know for sure if you were under the influence at the time that you were driving and how much of the THC in your blood was causing impairment at the time you were driving. So getting an attorney who understands the nuances of marijuana and blood tests can help you to win these. Unlike alcohol, when you're arrested for a marijuana DUI, you do not have the option of a breath test or any other test. It's always tested by taking your blood. Now, this causes a lot of issues that can both hurt and help you, as blood tests are more accurate. However, there are different ways to test the blood and to question it also. Having a good marijuana DUI attorney who understands the implications and ways to beat blood tests is crucial when hiring a DUI attorney. Unlike an alcohol-related DUI, a marijuana-related DUI does not have a threshold amount for how much THC you can have in your blood. So, for example, in an alcohol DUI, there's, by code, you are under the influence if you have 0.08% or more alcohol in your blood. While with THC, it can be almost any amount of THC in your blood, which causes great issues, mostly because THC will stay in your blood for several days after smoking. So it's important that you get a good DUI attorney who can help you to navigate through that and argue with the DA on whether or not you were actually under the influence at the time that you were driving. The legalization of marijuana has had a huge impact in California on marijuana DUIs. In some ways, it's made it harder, and in other ways, it's made it easier for you to be charged with a marijuana DUI. Previously, if an officer pulled you over and smelled marijuana from your car, that was pretty much all they needed to get probable cause to then further question you or get you to do field sobriety tests to test your impairment so that they could move forward then with a blood test and an arrest. In most cases, marijuana DUIs come from an admission of the driver as to the last time they smoked marijuana. So again, if you want to avoid a marijuana DUI, keep your mouth shut. Do not admit to the officer when or if you've had marijuana and when you have taken it. Because there is no legal threshold for the amount of THC that you can have in your blood and be considered intoxicated for a marijuana-related DUI, there are several nuances that a good marijuana DUI attorney will use to argue with the DA that you were not under the influence at the time that you were driving. Again, THC stays in the blood for much longer than alcohol. This is why it is very important, if you're ever pulled over for a marijuana-related DUI, do not agree to do the field sobriety tests. The field sobriety tests are only there and only given to you as means to prove your intoxication, to prove your impairment for driving. And without those field sobriety tests, it can be very difficult for a district attorney to prove that you were under the influence at the time that you were driving. If you've been arrested for a marijuana-related DUI and have any questions, call the marijuana DUI attorneys at Earl Carter Associates.